This is a classic example of the harrowing and tortuous trauma that a child suffers where his parents are litigating over his custody. Our experience has shown that children are unwilling to go to courts or to be taken there under orders, and many of them have told us, in unequivocal expression of angst, that they feel that they are being paraded as articles rather than as humans. Even when custody arrangements are made, with the place of exchange being fixed as the court premises or the office of the chief ministerial officer, we have found similar dread being expressed by children. And hence this bench has been very cautious in our approach, ensuring that the place of exchange is a neutral one and never the premises of courts, as far as it is so possible. Most often in matrimonial litigations, one misses to sufficiently recognize the obvious fallout of the strife between the parents and the horrific effect it has on the children, though, interestingly, both sides rely on the concept of welfare of the child as the final weapon to fight each other. This is an enigma, and we would assume that this is because the parties are often consumed by the passion of the litigation and the nuances of the controversy presented rather than by the realities of life. The pernicious effect of all this on the children is apodictic, and, as we have said above, the reaction of child in this case is a rude eye-opener even for us. The tears that rolled down the cheeks of the child, the call for deliverance which he made before us in his innocent tenor, and his remonstrance in being called into courts to be dehumanized every time, surely requires us to sit up and take notice. It is irrefragable, therefore, that we cannot offer approval to the order now impugned, and that it will be imprudent for us to even suggest that the child go with the father in permanent custody. The arrangement earlier settled by the learned family court was certainly enough for both the parents to have shared custody of the child, and its modification was unnecessary. But we understand the learned family court did so only because it was under the incorrect impression that it is the mother who was refusing to let the child be with the father. The fact remains to the contrary, as we have seen. And as long as the child is obdurately unwilling to go to the father, his claim for his permanent custody remains untenable. This ought to have been better assessed by the learned family court since it has recorded that the child was unwilling to interact with it, even when he was produced before it, thus limpidly indicating that all was not well with him. Though the specific controversy at hand has been so answered, we deem it unexpendable that we leave an epilogue for guidance of the learned family courts, for future reference since the exposure of children to the judicial system, be that for interaction or for other purposes, ought to be empathetically recognized by the courts to leave a trail of distress in them in the future. We, therefore, order that, except in exceptional and unavoidable circumstances, the presence of children in court halls and in public areas of the court premises, even for the purpose of counselling or such other statutory proceedings, be ordered sparingly and with great caution. Even in cases where children are so asked to be produced, every care ought to be employed to ensure that they are treated with the highest amount of dignity and privacy that any child would require, and are not made to wait ad infinitum for the proceedings to get over, but given preference subject to the workload of the court. When it comes to the place of exchange of the child for interim or final custody, we order that the use of the court premises, which we understand is essentially to enter such appearance in the registers maintained by it, be avoided unless exceptional reason is recorded, and a neutral place be thought of, preferably as per consent of parties, since this will, to a large extent, reduce the strain of the children and their fear, which they unfortunately endure on account of being forced to submit themselves to processes over which they have no control on and which they did not seek. To paraphrase, it is only in unavoidable circumstances, when the situation so expressly warrants, and to be recorded in writing, that the place of exchange be ordered to be the court premises. And in all other situations, we direct that an apposite neutral place be identified and fixed. We direct the registry of this court to circulate a copy of this judgment to all the learned family courts for compliance.